Good morning. My name is Lieutenant Lisa King. I'm the officer in charge of the Philadelphia Police Department Gun Department Unit. This is my first time doing something like this, so please bear with me. Thank you. Thank you for taking the time to consider House Bill 2536. The concealed carry loophole aims to remedy a real problem threatening police officers executing their duty to protect communities in Philadelphia and across the Commonwealth. In Philadelphia, there are currently more than 23,000 active permits to carry a concealed firearm. In 2009, we received roughly 5,500 new applications for concealed carry permits and granted approximately 5,000 of them, which would be a 90% approval rate. In 2008, we received 6,200 and granted approximately 5,900 at a 95% approval rate. The Philadelphia Police Department reviews and grants permits based on the guidelines established in Pennsylvania Code 6109, which enables us to prevent individuals who pose a threat to the community to receive a Pennsylvania permit to carry a concealed gun. This protects the neighborhoods, and it also protects the police officers who serve those neighborhoods. We try to reduce their risk by blocking individuals who we know to be dangerous based on criminal record, psychological problems, a history of violent or antisocial behavior, and local knowledge. In recent years, however, as police officers conduct their duties, we have noticed a trend of suspects who are ineligible for Pennsylvania concealed carry permits. Carrying a concealed firearm with a permit to do so issued by the Florida Department of Agriculture. These are oftentimes criminals who were either denied a permit to carry, who had their permit to carry revoked after an incident, or who knew, and some even admitted to knowing, that they would not be eligible to carry in Pennsylvania. In some cases, the suspects had even filed an appeal and had the permit denied and upheld before our board. Here are just three examples, or some examples of situations and situations our police officers have been put in as a result of this real problem. Case number one. Robert T. of Philadelphia had a lengthy criminal arrest history. He has been arrested 6 times since 1997 for crimes such as terroristic threats, harassment, aggravated assault, presenting false ID to purchase a gun, carrying a gun without a license, and other related offenses. This individual was convicted in 1997 of making terroristic threats in Delaware County Court. He was convicted in 2004 of carrying a gun without a license in Philadelphia, a first-degree misdemeanor. This conviction made Robert T. prohibited from possessing or owning a gun permit to carry in Pennsylvania. On June 23, 2008, subsequent to the Pennsylvania conviction, Robert T. obtained a permit to carry a concealed gun from the state of Florida from the Department of Agriculture. On July 27 of 2009, Robert T. was stopped by police for careless driving. The car windows were tinted, preventing officers from observing the occupants. The officers asked for the license, insurance, and registration, and for Robert T. to lower his windows and turn off the car. He closed the tinted windows and refused to exit the car. Police called for backup. They ran the license and registration and discovered that this Robert T. had previous arrests for aggravated assault by handgun and terroristic threats. Robert T. eventually surrendered. Robert T. told police he had a permit to carry a concealed gun from Florida. And just to add into this section, if he didn't tell us that he had a permit to carry from Florida at the time of this incident, we wouldn't have known. For the last 10 months, Philadelphia police have tried without success to have the Florida Department of Agriculture revoke or suspend Robert T.'s Florida permit to carry. It's still an active permit in Florida. It's still active. The second case is Sanford K. of Philadelphia. He applied for and received a permit to carry a concealed gun from Philadelphia in 2006. And he also applied in 2006 to obtain a Florida permit to carry. In July of 2008, he was involved in an incident with a stolen cell phone. He went to the location near Temple Hospital and offered to sell the stolen phone back to the victim. A dispute ensued, and the victim said she was calling 911. Sanford K. pulled up his shirt, revealed a semi-automatic handgun, and pointed directly at the victim and demanded the money. The victim grabbed the phone and ran, but not before taking pictures of Sanford K. as he drove away in the vehicle, as well as she got a picture of the tag. He was stopped by police. Right after the incident, he was charged with robbery, possessing an instrument of crime, theft, simple assault, and other offenses, and he was found guilty. So Sanford K. is a convicted felon who is currently incarcerated in jail. He was sentenced to 6 years. He still has an active Florida permit to carry. I've been in touch with Florida numerous times to ask them to revoke this permit, and it still hasn't been revoked. And sending them copies of all the paperwork, sending them that this is a convicted felon, talking to them on the phone to let them know that he is incarcerated. The next case is Gene P. Gene P. of Philadelphia is a Pennsylvania resident with a lengthy arrest record, including convictions. Mr. P. was arrested in New York. I believe this one was talked about already by Mr. Brady. He was arrested in New York. He was convicted of these charges, which prohibited him and make him ineligible to carry in Pennsylvania. In February of 2010, he was arrested in Philadelphia for carrying a gun on public streets, on public property, a first-degree misdemeanor. He handed police officers an expired Pennsylvania permit to carry and a Florida permit to carry, which was valid until 2015. Gene P. also had an active temporary protection order issued from New York against him, which expired in June 15, 2010. I was on the phone with Florida prior to this expiration of this protection order, and they were still giving me a hard time about revoking his permit with a valid protection order issued from New York. I called New York, got the information from them, sent the paperwork on, and they still just give you a hard time about revoking it. Based on the order of his other convictions, Gene P. should not have had any active permits to carry a concealed gun. In April 2010, Mr. P. applied for a Pennsylvania permit to carry. His application was denied. He came back and he tried to apply again. His application was denied. We sent proof of his convictions and the protection order to the Florida Department of Agriculture to suspend or revoke. Understanding that these cases might have been exceptions, I personally reached out to Florida Department of Agriculture to bring the problem to their attention and have been met with a fairly slow response to our department's concerns. There are literally convicted criminals in Pennsylvania jails who still have active Florida permits despite having their Pennsylvania permit revoked, because Florida is either unaware of their situation or unwilling to promptly take action to revoke their Florida permits. In an attempt to address this growing problem, we requested a list of Philadelphia, Pennsylvania residents with Florida permits that we could cross-reference our own database to see if any have had a permit denied, revoked, or were ineligible, and then notify the Department of Agriculture. Our request was denied. In Pennsylvania, the decision to grant a concealed carry permit is made by local law enforcement officers, county sheriffs, who are assigned the task of reviewing applications to decide whether or not to allow or deny requests. By putting the authority in the hands of local law enforcement, we can reduce the risk of allowing criminals to legally carry a concealed firearm without blocking the ability of law-abiding citizens to do so. In Florida, the authority to review applications is not assigned to law enforcement. It is handled by the Florida Department of Agriculture, who are civilians. And in conversation with the Department of Florida and a woman that I spoke to on the phone, they don't have the ability to check to see if somebody who is applying from Pennsylvania has an active protection from abuse order issued against them. So they're issuing permits not knowing whether a person in Pennsylvania has a valid protection from abuse order issued against them. This is not a reciprocity issue. This is about law enforcement. In Pennsylvania, we are happy to honor the permits carried by Florida residents visiting our state, and likewise. It is understood that Pennsylvania residents may use their concealed carry permits in Florida. That's reciprocity. This loophole is just a loophole, not reciprocity, and it's growing wider, and we believe it is dangerous to our citizens and our officers. And let me just say, the majority, in my opinion, the majority of people who are issued the permits to carry in Philadelphia are law-abiding citizens. Of course, like anything, you have your people who shouldn't have them and who should be denied based on prior criminal history and other things that are important. The Philadelphia Police Department believes that in Pennsylvania residents should be subject to Pennsylvania laws as administered by Pennsylvania law enforcement. This loophole undermines the authority of Pennsylvania police, putting officers at risk and eroding our ability to protect our communities. Thank you again to this committee, Mr. Chairman, and everybody else on the board, and the members, and for accepting my testimony. And I would also like to add that the Philadelphia Police Department supports House Bill 2536 to close this dangerous loophole in Pennsylvania law.
Thank you. Thank you for your testimony. Are you in touch with sheriff's departments around the state of Pennsylvania about this issue, or about what you're seeing as a trend when it comes to people getting permits from out of state?
It's hard to, the trend's happening, it's hard to monitor it, again, because we don't know what residents in Pennsylvania are applying for the permits to carry. I've been to some meetings where I've been with the other county sheriffs who issue, and yes, they're having issues with people that live in their counties who have permits from Florida that they're aware of.
And of the incidences that you recited for us, is it fair to say that none of those people had any connection to Florida, that they all lived in your case, in the city of Philadelphia, and that they weren't like former Florida residents, they were people that lived in Philadelphia that had just gone online and gone in the mail in Florida?
That's correct.
If a person living in the state of Florida, a Florida resident, somebody with a house in Florida and a Florida driver's license, were to call the Philadelphia Police Department and apply for a Pennsylvania permit to carry a concealed weapon, would you issue it to a Florida resident?
If the Florida resident had a permit from Florida,
Yes.
and they were in Pennsylvania and they wanted to obtain a Pennsylvania permit to carry, they can.
Okay.
Because they have a valid permit from Florida.
Relying on the Florida permit.
Correct, but they really don't need to get one from Pennsylvania because we reciprocate, so they would be covered.
Right. And are you aware of any sheriff's departments in Pennsylvania that are issuing concealed permit carries to people, to residents of other states, except in those situations where they have a reason to come here for business or some other reason?
Not that I'm aware of.
Okay. And just so we understand the problem, when these folks that you've listed for us, when they are out on the street carrying a gun with that permit, they have the peace of mind to know that if you don't happen to run them through the computer, if an officer, has a stop and frisk and he recovers a weapon, and they produce that Florida permit, that officer is obligated under the law to give them the gun back and send them on their way. Is that accurate?
Well, the officer's obligated to conduct an investigation. You stop somebody with a permit from Florida, you have to verify that it's actually valid. Is it revoked? Just like we would do in Pennsylvania. If you're stopped and you have a Pennsylvania permit to carry, the officer's going to run you through the systems to see if your permit is valid and not in the revocation status. With Florida, a person has a permit from Florida and you stop them on 4-12, you're not getting a hold of anybody in Florida to verify if that permit is valid or not. When you call the number on the back of the permit, you're calling their day work crew if they're not working. So now you're the officer on the street, you have somebody with the gun, somebody for the permit, you don't know if it's valid or not.
And if that person turns out to have a valid permit, even if the officer, let's say he's in the police district right to the east of here, and from his experience in the neighborhood, he knows who the guy is, he knows who he hangs out with, but finds that it's a valid permit, and he's got to give him the gun back and send him on his way, even if he knows the guy's up to no good. Is that fair statement?
Some officers might do that not knowing that. Yeah. In my opinion, if you as a law enforcement officer know that that person has a criminal history record and they're a scumbag, basically, and you know them to be that from the neighborhood.
That's a legal term.
That's a legal term. I know one.
Yeah.
That you should take the gun. The gun goes on property receipt. The permit's confiscated. And they should notify the gun permits unit, and then we'll reach out to Florida and try to resolve this situation, which, again, for something like that, for us saying this guy has 9 prior arrests, the one guy that I was talking about, he has 9 prior arrests for narcotics and ag assault, terroristic threats. He never applied in Philadelphia. He has a